Madiya Vanakkam. My time slot was 11:23, so I learned from Sister Bhanumati Kalai Vanakkam. But the Kalai Vanakkam is over now, so Madiya Vanakkam. Congratulations to the Bar Council of India and Bar Council of the State of Tamil Nadu and the local man, Mr. Prabhakaran in particular, in organizing this mega show. It's a great event, no doubt about it. But as Sister Bhanumati rightly cautioned, it is not what we see in ITC that is to be carried, but what we have learned from ITC today that we have to carry forward. Well, as our esteemed Chief Justice, Justice Sanjay Kaul cautioned, the public is the master. You know, the judge is a public servant. You have a lot of definition in the IPC and various acts, also public servant. That means one who serves the public. So we are all that way serving the public. But do the public have that feeling that we are serving them? They have a feeling otherwise. Why? I just thought of analyzing 2-3 aspects and just to have an introspection as to what we could do, both as judges and lawyers. This confidence of the public is shaken now because we as judges or as lawyers do not see them as masters. Well, ours is the only profession where the Bar Council regulations defines a lawyer as a gentleman. Well, do the public have a feeling that we are really gentlemen? And judges do not cease to be gentlemen when they move from the lawyer to the judge. They are to be model gentlemen. Well, do the people have a feeling that they are the judges, be it from the office or up to the Supreme Court, are gentlemen or even model gentlemen? About the delay, that is another reason for the confidence being shaken. According to me, a judge who hears a case must deliver a judgment preferably within a month, and in any case within 3 months, as has been cautioned by Justice Thomas in the judgment. Not more than 3 months. Then what happens if a judge does not deliver a judgment in 3 months? I would tell the Chief Justice, whether it is Chief Justice of India or Chief Justice of the High Court concerned, should not allocate work to a judge who has judgments pending for more than 3 months. Let the judge do that work, and then alone this work need be allocated. Let them, those judges whose judgments are pending, let them write the judgments first. But there's no point in piling up the judgments and giving to the judge, because he will be in more confusion and more pressure. So let the judges finish their work, and till such time, after more than 3 months, if a judgment is pending, the Chief Justice concerned should not allocate a work for the judge. Then the people will come to know what this judge is doing. On the side of the lawyers, Justice Kaul has already mentioned about the strike. You know, there's a judgment, not one, 3 judgments that lawyer cannot strike work. When if you ask me bluntly, when you strike work, you are striking at the left or right side of the face of that poor litigant. You have other modes of recording your protest. Resort to that. Additional work is one mode. But there are other modes, or the father of the nation has given to us, how we record our protests. And I would say, I was deeply pained when the Bar Council of India itself called for a strike. Be the issue be of any serious magnitude or concern, but a regulator like Bar Council of India or Bar Council of the state concerned shall never call for striking work in courts. They shall be doing a disservice to the people if you do this so. And for lawyers on adjournments, never ask for more than one adjournment. If you ask for more than one adjournment, please be kind enough to have alternate arrangements. That shows you are not prepared to do the work. So please entrust the work to somebody else who will do the work. And to my media friends, never ever quote or criticize or work upon oral comments of the judges in benches. just ignore them. A judge is expected to speak only through his judgments on the judicial side. While performing work as a judge, if he makes a comment in the bench, never ever build upon that. Leave it to the bench and let it rest there. Never build up a case for putting up pressure or putting up sides or otherwise of the shadows. Now most of the work that you see published either in the print media or in the telecast in the electronic media, or that you have the discussions are all on the oral comments of the judges. If the media takes a decision that we will not publish or telecast or broadcast the oral comments made by the judges, then that will be the day one, the media's great service to the nation and great service to the institution of democracy, in particular through the service of the judiciary. Please also stop trying in the media. Till a case is over, never try a case in the media. It creates a lot of pressure on the judges. They are also human beings. The amount of pressure that you build up, I don't want to speak here because I wanted to speak on a specific instance of the Nirbhaya case. That judge once told me, if I had not given that punishment, they would have hung me. This was what he said. Because already before the judgment, the media had already given up their verdict that it is going to be this only. And if that poor judge does not give this verdict, but because he had to give it because he had reasons to do it. Not because the media said it, but he had reasons to do it. But he was also making a casual remark that had it not been done, the people would have hung him because that was the type of pressure. So never ever resort to this media trial on an issue. You do it after a judgment is delivered, and you have a lot of other materials also getting why a judgment is that way. Well, one thing to the law minister also. In the sense, he is actually the man who has to take the judiciary, the institution, the law in the country, etc. And he is actually the man representing the rule of law in the legislature and in the executive also. Please be kind enough to visit one official court in a state, in every state, along with your counterpart in the state. Take your law minister of the state and visit one official court, not the palatial buildings of the high courts like Madura. There you have, I am not envious of you, but you have very good building. I am really happy that, the center and state have supported that. But see the outhouses. I'll call them official courts the outhouses. Go and see the outhouses in the official side. You will feel pity for them, and we will feel sorry that we are having this system. So they are the common man. The butcher, the baker, and the candlestick maker deals there, not in the High Court or Supreme Court. There, you must go and see those places and see what we can do in developing such a system. Well, I have a few more suggestions, but I have a technical session more also. I'll just thank you very much. All the best. Nandri. Yes.
Nandri Nidiyarasar avargale. I'm certain that the press will take your lordship's suggestions seriously and will act as a fourth pillar of the democracy.
I left and come to the right. Very good afternoon to all of you, my brothers and sister judges and other members of the family. We had a very sumptuous lunch, and we have now fused the two sessions also. And I have to catch a flight also now. So I just thought of moving right and going this way after putting a couple of my suggestions. Well, we must all keep in mind that a person comes to the court out of right, not out of the charity of a judge or not out of any permission given by the lawyers or somebody else. No, they have a right under the Constitution. So if they have a right under the Constitution to seek legal redress of their issue or grievance or problem, as an institution, we have a duty to respond to that. And that response, not by judge alone, you as advocates also is part of it. I just looking at that light also. True, we lit it, but without you, the lawyers, the oil in it, it won't give you the light. So you are part of the system. integral part of the system, unavoidable part of the system also. So we must all strive together to protect the dignity and self-respect of the clients or of the litigants who come to the court. I always used to ask a question to my judicial officers wherever I was. Whether a person who comes to the court as a litigant, does he come out of the court with the feeling that I had my right vindicated, my dignity has been protected, and I'll come back to the court only if at all I have any future grievance? All of them says no. All of them said no. Nobody goes out of court saying that my dignity has been protected. What's the problem? We have a duty to do that. So together we must try to protect the dignity and self-respect of the litigant. That is a very important part of the litigation aspect. Second and the last, see, we are all lawmen and not laymen. Laymen can take resort to any remedy they want for redressal of the issues. But as lawmen, we believe in rule of law, and we have only that rule of law with us. So if we have a problem, be it with the police, be it with the executive, be it with some other issue agency also, take recourse to the legal remedies and not go to the streets or not take to the streets. It will be far stronger for you to have legal recourse to your problems. And the system is to solve the problems. If somebody else had the problem, they would have come to the court. Then why we, the lawyers or the other group, do we take it to the street? We can't do that. If we advise others to come to the court and seek your redressal, we can't do otherwise. So take legal recourse to the issues also. Thank you very much. All the best. Congratulations once again for the wonderful organization.